Welcome to Halton SENDIASS podcast. I'm Sharon English, and today I'm going to be talking through the process of consultation. Consultation may apply whenever there is a draft stage EHCP. When a draft EHCP is issued, you must be afforded at least 15 days to review, comment, amend and make representations about the draft plan. At this stage, you also have a right to request a particular setting of your choice. This has been covered in a previous podcast, so please do have a listen to that and follow some of the links that were on there so that you are fully informed and know what types of schools you can request and what must happen when the local authority make decisions around naming. When the local authority receive a request for a particular school or setting, then the Children and Families Act and the SEND regulations contain many duties on the local authorities. And one of these duties is to consult before certain decisions are made. The decisions for which a local authority has a duty to consult are what nursery or school or college to name in a plan. Here it's consulting for the settings views on whether it should be named or not, and before they decide whether to name it. They should consult when they're deciding whether to secure special educational provision for a child or a young person who requires otherwise than in a school, nursery or college, because it would be inappropriate for them to be educated in such a place. Also, they must consult with you when concluding an annual review in order to help them decide what decision to make. So will they keep the plan as it is? Will they amend it? Or will they cease it? When a decision to cease to maintain a plan, there is also a clear duty to consult with you and the setting around this decision to help the local authority decide if it can legally be ceased or not. The local authority is required to consult. It must carry out the consultations lawfully. This means that consultations must take place at a time when proposals are still being considered, not when a decision has already been made. The local authority must give at least 15 days for schools, settings and nurseries to respond to the consultation, and any responses received must be properly considered and fully taken into account when they are making decisions. If the school or the setting or the other local authority fail to reply in the 15-day window, then the local authority does not have to wait to make a decision about naming a school or a college. They still need to stick to the legal deadline for issuing that final plan. Your LA should issue the draft plan or the amendment notice well before the deadline, making sure that it complies with its consultation duties. The final decision on which school or setting or nursery to name rests with the local authority where the child or the young person lives. Even if the school or college and or the local authority where the college or school is located, if different from the home authority, objects, then the home local authority can still choose to name the school in the plan. That said, they must consider the response to the consultation carefully and in line with its duties to carry out lawful consultations. So, just to recap, local authorities are under a legal obligation to consult with schools and settings when seeking to name an EHCP. There are key steps that must be followed to ensure that that consultation is lawful. The consultations must occur when the proposal is at a formative stage. Local authority must include sufficient information to permit the school to intelligently and properly consider and respond to that consultation request. Adequate time must be given to the schools and settings to respond. 15 days at least. And then the consultation response must be conscientiously taken into account. This has been confirmed in important case law that relates to statutory consultation that local authorities must undertake. For schools, in practice, this means that before they respond to a consultation, they should consider whether the local authority has provided sufficient information so that they can properly consider the request. This will include the schools checking that the local authority has provided copies of documents referred to in Section K of the EHCP and any other relevant reports and, if appropriate, annual review documentation. They should have a look if advice has been received from all the relevant professionals, such as EPs, occupational therapists, speech and language therapists. And they should also look at the appendices and reports provided are recent enough to form a current picture of the child's needs. Typically, those older than 2 years are considered outdated. Thank you for tuning in and for listening to the information all about that consultation process. If you do have further questions, please do contact SENDIASS using the details that can be found on our website.